Good morning, everybody. We're here today for oral arguments. We're going to begin with appeal number 22-2067, Hurlston versus Costco, and we're going to start with oral argument from Attorney Maddox.
Good morning, Your Honors.
Good morning.
May it please the court, my name is Jamie Maddox, and I represent plaintiff appellant Karen Hurlston. The jury verdict in this matter should be set aside because the errors that occurred at the trial are compounded by each other. Specifically, the jury was given an instruction that was contrary to law, which led to confusing and misleading jury verdict forms. Further, the photographs, which lacked a proper foundation and were admitted over the objection of Ms. Hurlston's counsel, allegedly showed how the accommodations proposed by Ms. Hurlston would not work. Ms. Hurlston's request for an accommodation caused Costco to then retaliate against her. The retaliation claim should have been analyzed separately from other claims. However, it was not. As to final jury instruction number 19, both parties agreed to the language in the final jury instruction, and as did the district court. The district court confirmed that the language would be changed, but it never was. The parties agreed that the following language would be omitted from jury instruction number 19, quote, "She proposed at the November 15th job assessment meeting," end quote. The court omitted that language. The court omitted the language "at the November 15th job assessment meeting," but did not omit "she proposed."
Tell us how you believe those two words so drastically affected the jury's deliberations.
We believe it drastically affected the jury's determination because the standard for a disparate impact claim or a failure to accommodate is whether or not, in this case, Ms. Hurlston was qualified to perform her job duties with or without an accommodation. What the law says is that both the employer and the employee here, Costco and Ms. Hurlston, must work together and both propose accommodations. But the language "she proposed" puts the onus directly on only Ms. Hurlston, that she should have only been the one to propose accommodations.
Ms. Maddox? Go ahead.
How are we to view that when we have three other jury instructions by my count that stress the importance of the interactive process and Costco's role in the process? So 17, 20, and 21. Should we just ignore that? Is it that 19? How do we view those together?
Sure, Your Honor. What I think is important is to look at the final jury instruction number 19 and the verdict forms together, because the question that the jury answered, the one and only question, was Ms. Hurlston qualified to perform her job duties, period. So I think final jury instruction number 19 really goes to that, to show that, number 19 and the jury verdict form should be the same, and that it's put on Ms. Hurlston in order to come up with those proposed accommodations, where what the jury heard the entire time was that Costco did accommodate her. We don't agree that they did accommodate her, but Costco's argument throughout the entire trial was that they accommodated her by putting her on a leave of absence. And so by hearing jury instruction number 19, the jury only looked to see whether the accommodations that Ms. Hurlston proposed would work, and not whether Costco proposed any accommodations.
So that I understand this correctly, Costco did not propose, and the jury didn't hear evidence of any accommodations that Costco believed would allow her to continue as the optical manager. Is that correct?
Well, what Costco proposed was a leave of absence, which they said.
Would you answer my question, please?
And can you repeat your question, please?
I'll try. Did Costco propose, and did the jury hear evidence of any accommodation that Costco proposed that would have allowed Ms. Hurlston to continue as the optical manager?
No, they did not.
Okay. I understand your point in the abstract, that if a jury were told, in essence, you may consider only accommodations that the plaintiff proposed, that would be a problem in general and in other cases. What I don't see is why it's a problem here, where the only accommodations that were before the jury to keep her in that job were those that, quote, she proposed.
Well, we would disagree because several times throughout the trial, in the closing, in the opening, in testimony by Julie Frazier, by Mike Donaldson, everyone said, yes, we accommodated
Yeah, that's
Ms.
kind of
Hurlston.
nonsensical, though, right? I mean, it's not accommodating her in the position of optical manager. It might be an accommodation to keep her employed by Costco, but we'll discuss that with the other counsel.
Well, and we would.
But on the jury instruction question, it's hard for me to see prejudice to your client if the only accommodations in front of her, of the jury, were the ones she proposed.
Well, and I think looking at it from a juror's perspective who doesn't deal with these final instructions day in and day out during trials, you know, they were told over and over and over again, yes, we accommodated her, yes, we accommodated her, yes, we accommodated her. And so when they look at the jury instruction, they're like, oh, wait, hold on, we can only look at what she proposed. And so I think that's what's important.
Okay, I'll stop trying on that one. Is it correct, Ms. Maddox, that you or your co-counsel did say on the record when the court provided its final instructions, that you were looking at number 19 and you had no objections?
Yes, that would be correct. But to put it in perspective, as we received those final jury instructions at 11:19 a.m., we went back on the record at 11:20. At that time, the only jury instruction that was at issue was what became final jury instruction number 20. And so that's what we were focused on and misspoke.
I understand it was a mistake, and I understand you were rushed. And I know trial judges want to get cases to the jury, and there's a lot of pressure on everybody. But is it correct that the record, just reading the record, says you approved 19?
That is correct, but what we would say is that regardless, we also have the plain error doctrine that if we did not object, there is still the opportunity if it affected substantial rights.
Could, oh, go ahead.
Thank you, Your Honor. As I stated before, Costco contends that it did not offer any reasonable accommodations now, but during the trial, several times, they did state that they provided a reasonable accommodation. And we believe if Costco, as the employer and a party to this case, was confused on what accommodations were made and what accommodations were not made, then we believe that the jury was confused and misled as far as what accommodations were given or not. And we believe because the jury determined whether Ms. Hurlston was qualified under the ADA based on whether a reasonable accommodation was proposed or existed, regardless of who proposed it. And because the jury ultimately found that Ms. Hurlston was unqualified, the inclusion of the phrase "she proposed" was a plain error of law. And I see my time is running low, and if it's okay, I'll save the remaining 7 minutes for rebuttal.
If you want to address any of the other issues, now's the time.
Sure. As far as the jury verdict forms, I touched a little bit on that. We believe number 19 and the verdict forms go together. And Ms. Hurlston's counsel was not afforded an opportunity to object on the record.
There's a clear procedural error under 51B here. But the question is whether there's any prejudice. And your argument seems to be that the question on the verdict form needed to include much more of the content of the instructions, rather than just assuming the jury's going to read that question in light of the instructions.
That's correct. We believe that the question should have asked, was Ms. Hurlston qualified to perform her job duties with or without a reasonable accommodation, as that's what the law provides for, is whether she can do her job duties with or without a reasonable accommodation. And we believe...
And the jury was instructed on that, correct? With or without an accommodation?
They were instructed on that.
Can you tell us more then about prejudice? How exactly was the jury misled as to the appropriate law? You've identified what you say is the error, but we've also got to see prejudice here.
Well, the prejudice is that they did not get past question number 1. They answered no, and we were done. And so we believe that including the language with or without reasonable accommodations would have gotten them to the next question, which we never got to do. So we believe the prejudice is Ms. Hurlston ultimately lost a jury verdict because of that question, because the language with or without a reasonable accommodation was not included. And we objected prior to the verdict forms being finalized that we wanted it to track the instructions, and it did not.
Is your evidence of prejudice really just the unfavorable jury verdict?
It is part of the unfavorable jury verdict. It's there were misstatements of fact and law made. As far as law, the with or without accommodations or she proposed were not included. Misstatements of fact, whether or not there was a reasonable accommodation, whether Costco believed that or not. So we believe that all goes to prejudice for Ms. Hurlston, and that her rights were substantially affected because of the confusing and misleading jury instructions and verdict forms.
I'd like to reserve the remainder of your time.
Yes, please.
Thank you.
Thank you.
We'll now hear from Ms. Sullivan.
Good morning, Karen Selden on behalf of Costco. The court should affirm the judgment because plaintiff has established neither plain error nor prejudice with respect to any of the three rulings that she challenges on appeal. I'll first start with the jury instruction, and then I'll address the verdict form and, time permitting, the two photographs. So instruction 19 defined whether plaintiff was qualified for the optical department manager position, and plaintiff contends that the she proposed language was in error. But as your honors pointed out, she can't establish any prejudice here for a couple of reasons. One, the only set of accommodations that were before the jury were the ones that plaintiff proposed. And that's because Costco determined, after reviewing the medical restriction form, after reviewing the job description, and after going through the accommodation meeting process, that there were no accommodations that would allow Ms. Hurlston to perform the job. And plaintiff didn't adduce evidence of any other unproposed accommodations that the party should have considered. And so the universe of accommodations would remain the same, whether the she proposed language was in there or not. So setting aside that there isn't any plain error here, plaintiff simply can't establish prejudice. Now, plaintiff talked extensively about the leave of absence, but I think plaintiff is confusing two things here. Question 19 is about whether she was qualified for the optical department manager role. And as I said, Costco determined that she wasn't, and so Costco did the next best thing, which is to offer her a leave of accommodation. So it's entirely consistent, and Costco's position has been all along that she couldn't perform the manager job, and so the only reasonable accommodation was to put her on a leave of absence until she could find a suitable position, which she did in the hearing aid department less than a year later. And so those are two entirely different things. And with respect to the interactive process and whether the jury was misled on that, as Your Honor pointed out, there were three other instructions that fully apprised the jury as to what Costco's interactive process obligations were. So there was absolutely no confusion with respect to that issue. And just quickly on the timing of when plaintiff received the instructions, I would direct the court to the record. The district court gave out hard copies of these instructions. It wasn't just that they were emailed minutes before.
How long were the hard copies given out in advance of the email?
So if you look at the supplemental appendix at page 215, you'll see the court directing her clerk to give out hard copies at 10:43 a.m. And then the parties recessed, and then they went back on the record and discussed the instructions until 11:36, and that's in the record at page 229. So that's almost an hour that plaintiff had two lawyers in the room who could have evaluated the instructions or at least objected that they needed more time.
And the email was 11:19?
I believe so. The exact timing of that is not in the record, Your Honor.
Okay, thank you.
And then turning to, unless Your Honors have questions on the instructions, I'll turn to the verdict form. You're correct, Your Honor, that the parties didn't see the very final version of the verdict form before it went to the jury, but that technical violation we submit wasn't plainly erroneous, and it wasn't prejudicial for a couple of reasons. The question that's at issue here, question 1, which is whether plaintiff was qualified, remained the same throughout. The district court didn't make any...
The way it's set up, though, on that form is that, as counsel pointed out, it doesn't ask about accommodations until after the question, is the person qualified?
That's correct, Your Honor, and
That
that's...
does seem like it could invite some confusion.
Well, we don't think so because the term qualified is specifically defined in Instruction 19. And in Instruction 19, the magic words with or without reasonable accommodation are there. Not only that, in closing arguments, both plaintiff's counsel and Costco's counsel explicitly told the jury that for plaintiff to be qualified, she had to be able to perform the job with or without reasonable accommodations. And in fact, Costco's counsel gave the jury a roadmap in its closing. It said, the key question is whether Ms. Hurlston could perform the essential functions of her job either with or without reasonable accommodation. The answer to that question must be she was not. And if you agree, then you're asked to complete the jury verdict form on this question, and we ask you to return a verdict for Costco. So there was a clear roadmap for what qualified meant and what the jury should do with the form. So we don't think there was any confusion there.
Ms. Selden, one of the things that's troubling about this case is that apparently Ms. Hurlston was performing her job successfully as an optical services manager, right?
The department was successful, that is correct. But what came out during the accommodation meeting was that she had been trying to work around her restrictions for years.
Which is perfectly normal, right? So
but for
I realize you guys may not be happy about it, but in essence, we had a status quo that was working for everybody. And it's only then when she comes in with the very restrictive specific limitations from her doctor and asks for formal accommodations in this remodeling process that everything blows up.
And Costco as an employer, once it's alerted to an employee's restrictions, and in this case they were quite severe, it can't allow its employees to exceed their restrictions and do things that their doctor tells them they can't do.
Yeah, it sometimes seems like there ought to be an interactive process that's three-way with doctor, employee, and employer.
And that might be appropriate in some cases. I think here the form being so clear and saying she could never bend or never stoop, and with the restrictions on the lifting and the standing, there was really no question that she was not performing the job. And in fact, she said that she would just ask other people to lift for her, or that she would just not do certain things, like if a customer was in front of her and she was having pain, she would sit down. So in some ways, she was not performing her job up to standards.
But at some point, she does come in and say that her restrictions really aren't as severe as the doctor's note would lead one to believe, that she can work beyond her restrictions. Was she then given an opportunity, or did she have the opportunity to get a revised doctor's note at that point?
She did, Your
Because
Honor.
I think the interactive process was still open at that point.
That's correct, Your Honor. Even during the meeting, and I think there's testimony in the record from Ms. Frazier on this, they were trying in the meeting to really figure out, really, you can't bend at all? How do you sit? I mean, they were essentially trying to get her to clarify her doctor's note. And it did eventually happen. There was a second job assessment meeting several months later in which she said, my doctor thinks I might be able to do more, at which point she was invited to submit another note, which she did. And based on that revised note, which loosened some of the no bending restrictions, they were able to put her in that hearing aid assistant position. So the interactive process continued for over a year. And then she was put in that position, then she was promoted, and then ultimately she had to take an unrelated leave of absence. But it wasn't that Costco said, okay, we're done with this meeting, we're done with you. It wasn't like that. Just veering back to the verdict form, the issue about the jury not being able to follow without the instructions being in there, I just wanted to point out that plaintiff's form, the one that they were proposing, was very short. It didn't have any of the jury instructions listed. And in fact, plaintiff's counsel, when advocating for her version of the form, said, you don't need the jury instructions in the verdict form because the jury is admonished to follow them. So at the same time that plaintiff was saying that Costco's form was too long, she was also saying Costco's form was too short. Her position sort of flipped back and forth. And so we submit that the district court did the right thing and committed no plain error with respect to the verdict form. I'm happy to answer any questions the court may have on the photograph issue, which I know plaintiff's counsel didn't address.
I don't think so.
Okay, well, thank you very much, Your Honors.
Thank you, Ms. Selden. We'll now move over to Ms. Maddox for you for rebuttal argument.
to follow up on a couple of the points that Ms. Selden was trying to make, the only thing that the jury heard was that Costco did provide an accommodation. There are several times in the record where they repeatedly state not only their counsel during opening and closing, and in the issue instruction, but also by their witnesses. For example, in the record on 1096, Ms. Frazier says, the question was, what happens if the employee can't be accommodated? Well, we accommodate them with a leave of absence. Another time, and since an accommodation is meant to help a disabled employee perform their job functions, a leave of absence isn't really a job accommodation, is it? And Ms. Frazier answered, yes, it is. There were several other times Mr. Donaldson, the warehouse manager, said that a leave of absence is a reasonable accommodation. And there was other points in the record on SA 192, SA 193, SA 233, and A 1158, where either their counsel or their witnesses state, yes, it's a reasonable accommodation.
Right, but it's not an accommodation that lets her do the job, and that's the question that is the focus of the instruction and of the first question on the verdict form, right?
Yes, and I think what one must do is put themselves in the position of the jury, and they're saying, well, was she qualified? Well, she couldn't do it. They're claiming she can't lift. They didn't give her an accommodation of a grabber. They didn't give her any accommodations. Thus, she was not qualified. So I think the important part is the with or without a reasonable accommodation language, and take out in the verdict form and take out the she proposed language in the jury instruction. And I know Ms. Selden stated that qualified to perform the job duties was defined in jury instruction number 19. So they had it because it says with or without a reasonable accommodation, but that goes back to the language that was in there that neither party agreed to, and the court stated that they would take out was the she proposed. So the jury was only looking at what Ms. Hurlston proposed. Ms. Selden also, and I believe the question was about a three-way interactive process that you stated, Judge Hamilton. They actually do have a third party they use called Briotics that they bring in order to have a third party say, what's going on. And I think in this instance, it was important to have that third party because, as Ms. Selden stated, they're asking, well, no bending, how do you sit? And I think that, what Ms. Hurlston kind of got flabbergasted about during the reasonable accommodation is like, I can sit. And so I think it's important to know that, she was saying, no, I can absolutely sit. And they're saying, no, you can't bend. And I think that's the part, as the employer, it's important for them to say, well, maybe we should get a third party in here. And she mentioned about the interactive process going on for a year. She was finally able to apply for a job. And so that's when it was done in April of 2016. And at that time, that's when she was given a demotion to the hearing aid department.
And it is a demotion. Can you speak to the pay difference? Is it about $13,000?
I believe it was about between $13,000 to $15,000 per year, and there was a difference in benefits. As a manager, you got certain benefits compared to an hourly employee. And just want to make sure I've covered all her points. We believe that here in this situation, the jury verdicts on the disparate claim and the failure to accommodate claim, as well as the court's verdict on the retaliation claim, should be reversed and remanded back to the district court for a new trial.
Thank you very much, Ms. Maddox. Thank you very much, Ms. Selden. The case will be taken under revisement. We're going to move now to Appeal 20-3151, Roberto Matta versus Mark Williams. And we are going to begin with oral argument from the appellant. And Mr. Rayfield, you may begin.
Good morning, Your Honors.
Good morning.
May it please the Court, Mike Rayfield on behalf of Roberto Matta. Mr. Matta was denied his right to counsel because his lawyer abandoned a meritorious motion to suppress based on no discernible strategy. I'm going to jump right into the state's procedural ruling, and I want to try to get to the heart of the matter by focusing in on one key case. The state court's procedural ruling was inadequate because, under the Illinois Supreme Court's decision in People v. West, a claim like Mata's doesn't need to be raised on direct appeal. It's supposed to be raised in a post-conviction proceeding because that's where it can be fully developed. The rule
So
in West...
sorry, go ahead. Tell us what West said, and then I'll ask you
Okay,
questions.
sure. So the rule in West is as categorical as it gets. It was a post-conviction case where the state argued that an ineffective assistance claim was barred because it wasn't raised on direct appeal. And the court said, quote, "We have repeatedly noted that a default may not preclude an ineffective assistance claim for what trial counsel allegedly ought to have done in presenting a defense. That principle is consistent with the cases decided on direct appeal, which have held that it's premature to bring a claim like this at that stage. Everyone agrees that West is good law and that Mata's claim falls within its category. It's about what a lawyer failed to do rather than not what he did. And for that reason alone, the state court's procedural ruling is inadequate, and that's true no matter what adequacy actually means in this context. Both parties have spent some time sort of parsing the distinction between whether a rule is established and whether it's correctly applied. But at the end of the day, in this case, the distinction doesn't matter that much. One way to look at the state's procedural ruling is that it's wrong because it's inconsistent with the rule in West. Another way to think a bit about it is that Illinois courts have been inconsistent in applying its rule, which means that it's not established as a matter of federal law. But one of those things has to be true. Either the rule is what West says it is, or the rule applied to Mata's case is not firmly established. But in any event, the state court's rationale in Mata's case was way off, because the record in Mata's case was not sufficient to resolve his claim. The state court simply held that because Mata's claim was based in part on, quote, matters in the trial record, his claim was barred. But the question is whether Mr. Mata had a full opportunity to develop the claim. The state court didn't even say he did, nor could it. There were multiple gaps in the record that were critical to resolving the claim. The biggest one is that the record was totally silent on why Mr. Mata's lawyer abandoned the motion to suppress the videotape statement. And we've cited several cases like People v. Ligon and People v. Parker, which have held that even fairly well-developed ineffective assistance of counsel claims were, quote, more appropriately addressed in a proceeding for post-conviction relief for that exact reason, to hear counsel's explanation. But beyond that, Mr. Mata explained that in the state court that the trial record didn't reflect the promises made to him in order to get him to agree to make the videotape statement. He wasn't given a chance to develop that claim, but we now know what his allegations were, which were that the police promised him that if he made the videotape statement, they wouldn't imprison his fiancée and his daughter wouldn't be taken away by the state. Now, under this court's and U.S. Supreme Court precedent, threats to a suspect's family are presumptively coercive. So without this evidence, he couldn't fully present his ineffective assistance claim.
From the trial counsel's perspective, though, that to introduce that type of information would be a challenge because Mr. Mata doesn't bring that up until much later. It's granted that the record does not reflect the reasoning with regard to the second motion. Is it reasonable inference that the counsel saw the video, didn't find it to be coercive, and dropped the motion?
Well, it's conceivable that he decided that the motion didn't have merit, but we can't say that without speculation, especially in light of the content and the posture of the motion. His lawyer filed the motion, apparently thinking it had merit. He won a closely related Fourth Amendment motion with very good findings by the trial judge on credibility, and then he just failed to get a ruling on the motion. He didn't actually withdraw it. He just left it sitting on the docket.
It's this strange statement, that was one other half of my motion to suppress.
I've read it 100 times. I don't understand it, Your Honor. And whether this was because of an oversight, or because he didn't want to take up the judge's time, or because he got overwhelmed with trial prep, we don't know. But it wasn't based on any strategy, and the state courts never supplied one. They just used the word strategy, but they didn't actually explain what the strategy was because it was never offered.
Mr. Rayfield, do we have Mr. Mata under oath in an affidavit giving that account of the coercion in the record?
Well, no, but we have his testimony at the motion to suppress hearing, giving that account. At the I'm sorry. So partially, we have.
I'm talking about the coercion before the video statement, the basis of this claim.
No, we don't have an affidavit from Mr. Mata.
Okay.
In the state court, I'm sorry.
In the state court, right.
Yeah.
So let's go back to West and talk about Erickson as well.
Sure.
And the state's arguments in this case. I understand them to be that you've got this passage in West that looks great for your side, right? But you also have Erickson, and there's language in West to this effect as well, that what matters is in essence whether we need evidence beyond whether the defendant is relying on evidence beyond the trial record. And here he doesn't seem to have submitted any evidence beyond the trial record with his PCR petition.
So just a quick qualifier on that
Okay.
on that point. Evidence, you're right. On appeal of the PCR petition, he did reference the promises in his briefing. But let me try to get to the heart of your question, which is how to reconcile my reading of West with Erickson. And I think I can. Erickson was not a case about what counsel should have done. Erickson was a case where the core of the petitioner's claim was that his lawyer called a so-called expert psychologist who didn't actually have a psychology degree. And so it was really a claim about what counsel did, and the facts needed to develop that claim were very clearly developed in the record. It had been revealed at trial that the expert didn't have a psychology degree. And then what's interesting about Erickson is after it explains that point, it then goes on to repeat West's rule. So I think the way to reconcile Erickson and West is that one is a case about ought to have done, and one is a case about what counsel did. But I don't even need to. That's not even my burden, because it's the burden on the state to say that the rule that the state applied is firmly established. If you think that West and Erickson are somehow in tension with each other, that means that the rule isn't firmly established.
What if we disagree with you and conclude that the rule is firmly established and the error that you're really complaining of at this point in the case is just an incorrect application to the facts of Mr. Mata's case? Do you still warrant relief under the failure to excuse the default for cause, the procedural default?
So we are no longer pursuing the for cause avenue, because I think the government correctly pointed out in its brief that Mr. Mata didn't pursue the appellate ineffectiveness ruling up through the Illinois Supreme Court, as we explained in our reply. But to answer your question more directly, if you disagree with my reading of West and you think that the question is whether the rule was correctly applied, I'm sorry, and you think that I'm sorry, I'm struggling with the framing of the question. But if you disagree with my ruling of West, and then I would still say that in order to determine whether a state court's decision is adequate, you have to look at whether what the LaBelle case says, whether it's being consistently applied. And that necessarily entails an inquiry into what the state law is and how it was, and whether it can be justified in Mr. Mata's case. Does that? I hope I've answered your question. Sorry.
Well, I'm actually having trouble with the concession here, because it seems to me that Mr. Mata, throughout his post-conviction proceedings, has always raised the issue of the ineffectiveness of not only his appellate counsel, but his trial counsel.
Yeah.
Because to look at one is to look at the other, because you can't resolve the appellate issue without looking at the trial counsel issue.
So I'd love to agree with you on this point, but unfortunately, Mr. Mata didn't make the appellate ineffectiveness argument in the Illinois Supreme Court. He didn't pursue it all the way through. That's why we conceded in our reply that that avenue is no longer available to us. So we have to show that the trial court ineffectiveness claim is not procedurally barred. If I could, I think you might have a question, Your Honor.
Let's suppose we get past the procedural obstacles here.
Okay.
There's no doubt that Mr. Mata shot all three of the victims, right?
Yes.
And we've got medical evidence they were shot in the back, right?
I think that medical evidence is disputed, but I'll accept the.
So let's suppose things had played out the way you're arguing, a motion to suppress had been granted. We still have Mr. Mata as the only shooter, victims all shot in the back, and his defense is self-defense. That seems, tell me how we get to prejudice.
Sure. So for prejudice, I don't think you really have to look far beyond. I'll answer those points directly, but I don't think you have to look very far beyond what the state court actually said in Mata's appeal, which is that the, quote, most salient evidence the state presented against the defendant and the most critical to proving his guilt beyond a reasonable doubt was the video statement provided by the defendant. I mean, I think, yes, we're not making a sufficiency argument, so there's no question that there was evidence from which the jury could have concluded that Mr. Mata's use of force was not reasonable. But this was a classic credibility dispute. Mr. Mata's testimony was that the men who assaulted Mr. Morris stood their ground, that they weren't running away, that one of them reached for his belt in what looked to Mr. Mata like he was reaching for a gun. Sure, the jury could have disagreed with all this and could have rejected it and it could have adopted the state's rationale. But in a case like this, as the state court pointed out, a videotape concession is going to make a difference.
But on the critical point, I mean, the video establishes he fires the shots, but the jury obviously did not believe what he said in the video, right? By way of self-defense or even imperfect self-defense. And they've got medical evidence showing these guys were all shot in the back.
Well, I think
that's what I'd like you to address.
So I'm a little confused by the question of did the jury did not believe what he said in the video. So the jury what he said at trial in his testimony differed from the video. The jury, what he said at trial was that the victims were not, or the men who assaulted Morris stood their ground, that they weren't running away, that he saw someone with a gun. This is different from what he said on the video.
Well, okay, there are two different versions he tells, right?
Yeah.
And neither one seems consistent with victims being shot in the back. That's my problem.
Well, his version at trial, his testimony at trial was that they were facing him, that they were backing away, but that they stood his ground. But that they stood their ground when the shots
I understand
were fired.
that's his version.
Right.
Reconcile that, please, for me with the medical evidence.
So if you look at Appendix 9, 10 to 11, what the medical examiner conceded was that his testimony was dependent on the location of the various people offered by the state, and that his account may have been different if the position of the various actors were different. But the jury, either way, the jury could have rejected the state medical examiner's testimony that he was shot in the back and accepted Mr. Mata's testimony.
How do you do that? I mean, seriously. Is there a dispute about the location of entrance and exit wounds?
Okay. So let's take what you're saying as given. There were several men who were attacking Morris. Let's say that two of the men were in fact shot in the back. There's still testimony from Mata that one of the men was reaching for his gun, and that and that he saw men firing shots. Remember, this is just this is Strickland prejudice. All we have to show is that there is a reasonable probability that the outcome would have been different if the video had been excluded. And I don't think I'm not even sure that in light of the state appellate court's finding that the video evidence was the most important evidence of his guilt, there's certainly a reasonable probability that the verdict would have been different. I see I'm out of my time, and I haven't reserved any, but I do want to answer Your Honor's question.
We'll give you some rebuttal time.
Thank you.
Thank you, Mr. Rayfield. We're now going to move to counsel for the state, Mr. Sebula.
Good morning. May it please the court, counsel, I'm Assistant Attorney General Michael Sabula on behalf of respondent. This court should affirm the district court's judgment for two reasons. First, petitioner's claim is defaulted because the state court denied it based on the Illinois forfeiture rule, which this court has repeatedly held is an independent and adequate state law basis that bars federal relief. And second, the state court also reasonably concluded that the ineffective assistance claim is meritless. If I could focus to begin on the issue of default, Illinois courts apply the forfeiture rule in a very straightforward way. When a petitioner files a post-conviction petition, the court looks at the petition. And if it cites evidence that was not part of the trial record, then the petition can go forward. If, however, the petition only cites the trial record, doesn't cite or attach any new evidence, then the court says this is a claim you could have brought on direct appeal, so it's forfeited.
What happens if the petition says, in essence, I can present evidence outside the trial record, but I don't have it attached to my petition yet?
Sure, Your Honor. Illinois law is well settled on that. If you think you have evidence that's outside the record, but you're unable to obtain it because, for example, you're an inmate in prison, all you do is you put in your petition, here's the evidence I think I can get. I don't have it now. Please let me move forward. Please appoint me counsel so that I can pursue this evidence. So, for example, in People v. Hobley, an Illinois Supreme Court case, there the petitioner alleged that his counsel should have supported a motion to suppress his confession with evidence about his medical condition and health problems he had. But he only cited evidence that was part of the trial record. So the Supreme Court said, well, that's a claim you could have brought on direct appeal, therefore it's forfeited. That's the exact rule the state court applied in this case. And that's no surprise, because if you look at the petition, as I think some of the questions got to earlier, there's no new evidence cited in there. There's nothing in there saying, I can get evidence if you give me a chance. To the contrary, if you look at the petition, particularly page 1529 of the record, you'll see that his primary claim was that this claim could have been brought on direct appeal. And in fact, he blamed his appellate counsel for not bringing it on direct appeal. So the state court's ruling results in default, as this court has held many times, Smith versus Gatz, among other cases. This is an independent and adequate state law basis. Now, my opponent has argued, primarily in his opening brief, that this rule is not regularly applied to claims about what counsel should have done, and he cites cases like West and Erickson. This rule is regularly applied to claims about what counsel should have done. As I just mentioned, People v. Hobley, Illinois Supreme Court case, applied it. We cite a number of similar cases on pages 20 and 21 of our brief. Now, as far as West and Erickson, West is fundamentally different than the claim raised here. The claim in West, the petitioner argued that his counsel should have presented a different defense at trial and should have retained forensic experts to testify that, to point the finger basically at another person for committing the murder. And he specifically said in his petition, he attached new documents to his petition, and he specifically said, I can't retain an expert to testify on my behalf now, I'm indigent, but if you let me go forward with my petition, I know I can retain a forensic expert to support my claim. That's fundamentally different than here, when petitioner made no such allegations in his post-conviction petition. And in fact, as I just said, in his petition, he specifically said this is a claim that could have been brought on direct appeal. He does focus on one sentence from West, where West says, I believe, claims about what counsel should have done may not be raised on direct appeal, and they may not be subject to the forfeiture rule. But you have to read that in context, because the only case that West cites for that sentence is Erickson. And Erickson is clearly a case where the Supreme Court applied the forfeiture rule to a claim about what counsel should have done. I think my opponent a few moments ago didn't really fully accurately characterize Erickson. The claim in Erickson was that counsel should have done a better job investigating the expert witness that they ultimately retained and found out he was not a psychologist, like he said. And he also should have retained other experts, and he attached affidavits from those potential experts. Still, though, the court said the documents that you were attaching, they really just duplicate information that was already known at trial. Therefore, your claim is forfeited. It could have been raised on direct appeal. So Erickson is clearly a case where the court applied the forfeiture rule to a claim about what counsel should have done. And in fact, Erickson cites other cases, including cases like People versus Jones, for that exact same point, that counsel should have presented evidence. That's a claim that's subject to forfeiture. Now, my opponent, in his reply brief, began to shift his argument a little bit and to say that under state law, he could not have raised this claim on direct appeal because we don't know what counsel was thinking. Counsel never explained in the record why he chose not to pursue this motion to suppress. There's a couple major arguments with that problem, which again, I think some of the questions got to. The first problem is that the post-conviction court specifically held that under state law, this claim could have been brought on direct appeal. So when he argues today that under state law he could not have raised this argument on direct appeal, what he's really saying is that the post-conviction court misapplied, misunderstood state law. Well, it's a fundamental rule of habeas proceedings that you cannot argue that a state court misapplied state law. And that's what the United States Supreme Court held in Estelle versus McGuire. And that prohibition clearly applies to state procedure rules as well. This court has held that in a number of cases like Oaks versus Pfister, Lee versus Foster. This court specifically said you can't avoid procedural default by arguing that a state court misapplied a state procedure rule. Now, to be clear, he can argue, as we clearly say in our brief, he can argue about whether the rule is regularly applied. That's an argument that requires us to basically do a survey of Illinois law, look at the entire body of Illinois law, and say, is this a claim that the courts tend to follow, or is it some obscure rule that's never applied? But he can't argue that in this specific case, it was misapplied. The second problem with that argument, as I just mentioned a moment ago, in his post-conviction petition, he specifically said this is a claim that could have been brought on direct appeal. So when he stands before you today and says he could not have brought this on direct appeal, he's taking a position that's exactly opposite of what he told the state court. Well, obviously, you can't do that in federal habeas proceedings. You can't tell the state court one thing, have the state court agree with you, and then take an entirely different position in the federal courts. The last point on this, if I may, he's just flat out incorrect when he says he could not have raised this on direct appeal because we don't know what counsel was thinking. Counsel never explained on the record what he was thinking. How do we know that he's wrong? One reason we know that he's wrong is that in this very case, on direct appeal, he raised a claim that his counsel should have impeached one of the state's witnesses with certain evidence. The state court on direct appeal resolved that claim on the merits. So that's a claim about what counsel should have done, where he had nothing in the record where counsel explained why he didn't impeach the witness, and the court resolved that claim on the merits on direct appeal. And in page 22 of our brief, we cite a number of other cases where on direct appeal, state courts resolved claims about what counsel should have done, where there was nothing in the record about why counsel did or did not take a particular position.
Can we address the PLA? Why would we be wrong to read the PLA as certainly the state law was the vehicle for Mata's claim, but at its core, he was challenging the state appellate court's decision that his ineffective assistance of trial counsel claim had no merit. So, we have to read the PLA in light of the state appellate court's decision. That decision bound up the ineffective assistance of counsel claims. Why would we be wrong to read the PLA that way?
So if I understand the question, why would you be wrong to say that his ineffective assistance of appellate counsel claim has been preserved through the PLA? Because he didn't raise it in the PLA. He only raised his claim that trial counsel was ineffective. So those are separate claims that have to both be raised individually through all three levels of state court review. So not just the appellate court, but also in the Illinois Supreme Court through the PLA. So my opponent was absolutely correct when he conceded that point. These are two separate claims. We don't ask, is this claim bound up? It has to be presented to the Illinois Supreme Court as a distinct claim. Because
My question is how one reads the state appellate court decision, which absolutely integrates these claims.
If I understand your question correctly, Your Honor, the Illinois appellate decision found that the claim about trial counsel was forfeited. It then reviewed the claim about appellate counsel because that's a potential excuse for the forfeiture. But he did not raise that claim in PLA, and I'm not aware of any precedent that says a claim that might be bound up in another claim it counts as preserving it through the PLA. So again, my opponent was absolutely correct to concede that point. There are separate claims that have to be raised through all three levels, and he failed to do that. If I could briefly make a couple last points on default, is that my opponent says a lot in his reply brief and today that we need to know what counsel was thinking. We can't resolve this claim without knowing what counsel was thinking. That is absolutely not the law of Strickland. Strickland imposes a presumption that counsel's actions are part of a reasonable trial strategy. Strickland expressly says this is an objective test. In Harrington versus Richter, the United States Supreme Court case that we cited in our brief, the United States Supreme Court expressly said courts should not be insisting that counsel explain on the record what they were thinking in order to resolve a Strickland claim. The court said this is an objective test, not a subjective test, and we cite other opinions from this court making that same point. We don't.
Do you think we could grant relief without giving counsel an opportunity to be heard to explain?
Could you grant relief?
You can deny relief
Yeah.
without hearing from counsel.
I would be happy for you to deny relief on that basis, but I don't think you could grant relief without him explaining. My opponent's theory is that his attorney just flat out forgot about this motion. As I understand, that's his theory in his reply brief, that he just forgot about it. So I think you would have to have counsel say, yes, I forgot about the motion for him to succeed.
Are you, in what you just said about Strickland, are you ignoring our precedent that when the challenge, action, or inaction results from inadvertence or inattention rather than strategic decisions, the actions are not entitled to a presumption of reasonableness? Can you address that?
Sure. I think the inattention, he cites one case, I believe, from this court for the inattention point. That was a case where I believe counsel just didn't do any investigation. So failure to investigate claims under Strickland are a little bit different than trial strategy claims. But
That case does not broadly say, I think you may be reading that case a little too narrowly to apply only to failure to investigate. It doesn't say that.
I disagree with my opponent's reading of that, but setting that aside, let's assume he's correct, and there is some broad rule that Strickland does not apply. All a defendant has to do is say my counsel was not paying attention. Let's assume that's the law. There's no evidence that this attorney was just not paying attention.
I think that's the difficulty here. It seems to me there's no evidence one way or the other. You say it was strategic. I don't see your evidence. He says it was inattention. I don't see evidence. The record is silent. And so we have a problem here.
Well, when the record is silent under Strickland, we assume it's part of a reasonable strategy. To answer I think I'm hopefully answering your question about inattention. The record would not support that. I disagree that we don't have record evidence that counsel's performance was adequate. This is an attorney who fought very hard for his client throughout pretrial and during trial. This is not an attorney. Nothing in the record shows this is the type of attorney who would just forget about a motion. He won pretrial motions. He called 6 witnesses to try to support a self-defense theory. And if we look at the record, some of the final pretrial hearings, it was specifically brought up to counsel. There's this motion pending. Are we going to schedule a hearing for it? Counsel had an opportunity to do that. What did he do? The first time he said, let's just continue the case. The next time what happened? They set trial. So his theory that counsel just forgot about the case or was not paying sufficient attention is contrary to the record. And again, we have to recall that we are in habeas proceedings. So there's a lot of deference that's given to the state court decision. He can't succeed just by showing it might be wrong. He has to show it was a completely unreasonable decision. And certainly some of the questions about the prejudice component, he can't come close to showing prejudice. The videotape itself shows someone who is not distressed, shows someone who's given a Miranda warning, shows someone who's said, I'm not being promised anything, I'm not being threatened. And of course, the evidence is that he shot these men in the back, which is exactly what the surviving victim said, is that we were trying to run away, we were shot in the back. With my remaining time, I just want to make one quick point because I think my opponent inadvertently misstated what the burden here is. This court's already found that the forfeiture rule is an independent and adequate state law basis. We have to show that it's regularly followed. This court has already held that. His burden is to show that, as this court has said, the United States Supreme Court has said, that it's applied so freakishly, so obscurely, so randomly that no one could ever suspect that it might be applied in this case. That's certainly not true of the Illinois forfeiture rule because, as we cite in our brief, this is a rule that's been applied time after time in cases just like this. So therefore, unless there are any other questions, we would ask this court to affirm the district court's judgment.
Thank you very much, Mr. Sebula. Mr. Rayfield will give you 3 minutes in rebuttal.
I want to start with the prejudice point, very briefly. It's important to keep in mind that Mr. Mata had two defenses here. One is that the use of force was reasonably justified to defend Morris and himself, and the other defense was that the use of force, he had an unreasonable belief in the use of force, in that the use of force was necessary to defend these men. So even if the evidence did show that the men were running away, the jury could certainly have concluded that the second defense, which would have entitled him to have a lower, to only a conviction of second-degree murder rather than first-degree murder, the jury could have concluded that he was entitled to that defense. So I think it's important to keep in mind this is not just about whether he intentionally shot the victims. That these are broad defenses that he was raising in this case. Now, as to the procedural bar, the government cites a number of cases where, including the appellate court in Mr. Mata's case, where the court addressed on the merits claims about what counsel should have done. But that doesn't mean that all that could have meant in those cases is that the state didn't raise the argument that it was premature. For example, in Mata's case, the state didn't argue that the claim that Mr. Mata's ineffective assistance claim on direct appeal should await the collateral proceeding. So there isn't that much to be read into cases like that, because it's entirely possible that the state just didn't raise this affirmative defense to the claims, and that therefore this issue just wasn't before the court. Now, as to the Strickland presumption of reasonableness, Your Honor is exactly right. Under this court's decision in Mosley versus Atchison, what I think the nuance that the parties are really disputing here is that what Strickland says is that strategic decisions are entitled to a presumption of reasonableness. But that doesn't mean that every decision is entitled to a presumption that it was strategic. And in fact, this court said that in Mosley v. Atchison. It said, quote, Strickland establishes a deferential presumption that strategic judgments made by defense counsel are reasonable. But the presumption applies only if the lawyer actually exercised judgment. The consequences of inattention rather than strategic decisions are not entitled to the presumption of reasonableness. And here, I mean, we're not just, whether or not you attribute this to inattention or not wanting to take up time or just simply getting overwhelmed, I agree that the record is silent on this one way or the other. But there is nothing in the record to suggest that the decision to abandon the motion to suppress, not to actually to abandon it, not to formally withdraw it, but just not to get a ruling on it, was not based on any strategy. And so finally, I just want to say we've asked this court to grant habeas relief, and if you think that the record is sufficient to conclude that the confession was involuntary, that's the relief we'd ask for. But I think at minimum, what should happen in this case is that the case should be remanded for the district court to hold an evidentiary hearing on the ineffective assistance of counsel claim. All these factual disputes about, say, what the medical evidence showed, what counsel's decision-making was, all of this other stuff is really an issue that should be decided by a fact finder in the first instance. So for that reason, we would ask the court to vacate the decision.
Thank you, Mr. Rayfield. Mr. Rayfield, you have the thanks of this court for your handling of this case as court-appointed counsel, including both of your firms, and showed great professionalism by you to take the case from one firm to another. So thank you very much.
Thank you, Your Honor.
Mr. Sebula, thank you very much for your advocacy as well. The case will be taken under advisement. We will move now to Appeal 22-2003, Andrew Stacy versus the United States. And we'll begin with argument from Mr. Nazarian.
Morning, Your Honors.
Good morning.
May it please the court, my name is Ken Nazarian. I represent the plaintiff appellant in this matter, Andrew Stacy. We are here today to discuss an incorrect application of an administrative offset on the behalf of Mr. Stacy. As Your Honors, I'm sure are aware, Mr. Stacy was incarcerated for a period of time after he had entered into a plea agreement. As part of that plea agreement, he was required to pay restitution. In this particular case, during the pendency of that incarceration, he required a hip replacement. He did not receive that hip replacement while incarcerated, and it resulted in a medical malpractice claim that we brought under the FTCA. After a full series of litigation on that matter, the United States and Mr. Stacy entered into a settlement agreement for $75,000. However, during that settlement negotiation, it was indicated to us that the Department of Treasury would be invoking the administrative offset in this case. We believe that allowance by the Department of Treasury was inappropriate, and we believe that it was either a misapplication of the law by the district court in this matter or an unconstitutional application of those statutes. For the following reasons, we believe that 31 U.S.C. 3716, which prescribes the requirements for an administrative offset, are inconsistent with the mandate of 31 U.S.C. 3728. We believe that the district court made an inappropriate determination that those applied in this case. We also believe that the statutes cited by counsel for the United States, 18 U.S.C. 3664N, is limited, as well as the 31 U.S.C. 3728 is limited to judgments as opposed to settlements.
Where do you see that in M1A1, strike that, M1A2, quote, by all other available and reasonable means, end quote?
Your Honor, I would argue that that is not an allowance to circumvent a settlement for a personal injury matter against an inmate who has been wronged by the United States.
You seem to be advocating a rule that applies only to personal injury claims that arise in prison. Is that right?
Correct, Your Honor.
That's a pretty narrow rule to tease out of the statutory language.
It is, Your Honor. However, I would argue that there are limitations that are prescribed in those statutes. For instance, in 18 U.S.C. 3664N, there is a limit to only during incarcerations that those would be.
Right, but not in M.
Yes, Your Honor. It allows for them to prescribe by any means necessary. However, the Congress was able to include settlements or any type of windfall in
But N is not limited to payments from the government, correct?
It is not.
It includes inheritances, lottery wins, royalties.
Correct, Your Honor.
Okay.
And it's conceivable that Congress had to have that specificity in for incarcerated people because there were all these other provisions that allowed for offset otherwise.
I would agree with that, Your Honor. However, that is exactly one of my points. With administrative offset, there are rules that go to the requirements in order to invoke that procedure. In Section 3716, it prescribes that there are 4 specific requirements to invoke an administrative offset, including notice to the party, an ability to review the claim, an ability to dispute the claim, and whether or not there is a written agreement that exists. And that all has to be in place in order for the government to invoke an administrative offset under that statute. Now here we have a written plea agreement. We believe that the written plea agreement is a written agreement to repay that debt, which would obviate the ability of the government to invoke 3716 and therefore the administrative offset.
The written commitment to pay prevents the offset?
Yes, Your Honor.
How does that?
I believe that as part of 3716, it allows that if there is a written agreement in place that allows for the defendant, or in this case the debtor, to repay the debts to the United States, if there's something already in place that prescribes how that debt is supposed to be written, that the government should not be allowed to institute an administrative offset per that statute.
But he's already behind. It was payable immediately upon sentencing, correct?
Correct, Your Honor.
Okay.
We believe that the plea agreement here is paramount, since there is that written agreement prescribed by the trial court and prescribed by the...
Did I miss this in your brief?
I don't believe so, Your Honor. I think that was in section 2 of the reply brief on pages 3 to 6, and then I apologize, Your Honor.
I thought this was a debate about whether this is a debt owed to the government.
Well, yes, Your Honor. That was part of the argument that we made on whether or not this was a debt owed to the government. We argued that this was a debt that was owed to specifically the victims, and that the United States...
To whom does he make his payments every month?
To the United States, Your Honor.
And do you have a response to Whitbeck, the Eighth Circuit's decision that says these are debts owed to the government?
Yes, Your Honor. I would agree that that is that was a point brought up by the United States. I believe that despite the fact that they are that Whitbeck indicates that there is a debt owed to the government, I do not believe that it should be considered as
I understand your belief. Do you have any authority to the contrary, given the statutory language and the precedent?
No, Your Honor.
Okay, thank you.
Would you like to reserve the remainder of your time?
Yes, Your Honor.
Very good. Thank you, Mr. Nazarian. We'll now move Ms. Reedy to you for argument from the government.
May it please the court. Counsel, if this court were to adopt appellant's argument that Stacy's compliance with a payment plan shields his other non-exempt assets from enforcement, then the United States, on behalf of victims of crimes, would have fewer rights than a credit card judgment holder. That is not the statutory scheme that Congress put in place here. The statutory scheme gives the United States many different avenues to collect a restitution debt for good reason, with the main focus being to make victims whole.
Ms. Reedy, can I ask you about jurisdiction in the district court?
Of course, Your Honor.
You have argued the district court did not have jurisdiction here. We've got pretty broad statutory language, and I don't see any contrary authority from you.
Yes, Your Honor. The United States position is that 1346 subsection C does not provide jurisdiction here. You are correct. This is not, based on our research, this is not an area that the circuit courts have weighed in on yet. The reason that we say that there's not jurisdiction here is based on the plain language of the statute. As, of course, Your Honor knows, this is a sovereign immunity argument, which means it needs to be strictly construed, and any waiver of sovereign immunity needs to be unequivocally expressed. Turning to the language of the statute, it is clear that it says whatever on the part of the United States against the plaintiff. This is not a provision that allows for reciprocal jurisdiction. This is allowing the United States to bring within the FTCA action, and let me make a distinction. We did not bring a set-off claim in the FTCA action. We never brought that as a claim in the action. Now, yes, the case, the FTCA case, was settled, resulting in a $75,000.
Okay. I think I understand you're splitting hairs pretty finely here. Let's suppose there is a serious dispute about the legitimacy of the set-off, and the government goes ahead and imposes it anyway on a settlement here. What forum is available, if any, for judicial review of that set-off?
Yes, Your Honor, the Federal Court of Claims, absolutely. But in addition, and it's not entirely clear, and if Your Honor is interested in supplemental jurisdiction,
So you'd have to go to the Court of Claims rather than to either the sentencing court or the FTCA court.
Yes, Your Honor, and
Why-
actually,
Why would you want to bring a third court into the case?
well, Your Honor, I did want to actually clarify. It may be that jurisdiction is available before the criminal case, before the sentencing court. And certainly that would be by far more appropriate than the court here. On reply brief, appellant brings up the argument that we did not comply with 31 U.S.C. 3716. I just want to note, and this seems like a sidebar, but the point is that when the criminal restitution judgment was entered, it would be part of the United States normal procedure under the TOP program to comply with the requirements under 3716. None of that factual information is on this record today. What Stacy is trying to do here is dispute his obligation under a criminal restitution judgment, and that should really be before either the Federal Court of Claims or possibly before the sentencing judge or the.
I don't know that he's actually disputing that original debt, is he? I mean, he's just saying, I get to keep this, or my lawyers at least get to keep a share of it.
Yes, Your Honor. I should say he is disputing the enforcement mechanism that the United States has for administrative offset. And one thing I will say, Your Honor, just in looking at this, the Seventh Circuit, an example of a case that would allow for jurisdiction under 3146 subsection C is Southside Bank and Trust Co. versus United States. That's a Seventh Circuit case. And it's an old case. It's 1955, but it's just a good example of when we think jurisdiction would be appropriate. And that was a case where a bank brought an action against the United States after the United States had a contract with a business to get 7 trailers. The business said, you're going to pay me a certain amount of money. And what happened is that when the United States, after the trailers had been provided, when the United States went to pay that business, we said, actually, you owe a bunch of taxes. And so our payment to you for the contract, for your services, is that amount. The bank brought an action against the United States saying, hey, I have these assigned rights. That was how I secured that debt. That was a case where the United States, under 1346C, brought a claim in that action. That is what is allowed under 1346 subsection C, not for Stacy to bring a wholly unrelated challenge to how the United States enforces his criminal restitution judgment against the United States here. If Your Honors have no further questions on jurisdiction, I'd like to turn to the merits. I will be making 2 key points, although, of course, if Your Honors have any particular questions, I can address. Oh, and one other point. There is several district courts that have weighed in on this issue, Your Honor, to the jurisdictional point. As you know, of course, Johnson, well cited in our briefs, and then Stacy, the court before the district court decision here. But in addition, U.S. versus Raytown Lawnmower Co., which is 763 F. Sup. 411, 1991. That is a case that, although it is not very detailed reasoning, it certainly supports the United States position here. But Your Honor is correct, there is little case law on this point. Now turning to the merits of the argument, I'll make 2 key points, but of course, if Your Honors want to direct me to any particular topic, I'm happy to do so. The first being 3664 absolutely allows the use of the TOP program here, and the second point being to the core of Stacy's argument that the payment plan somehow shields the use of enforcement to his other non-exempt assets. To that first point, 3664, as Your Honors noted, subsection M specifically uses an or conjunctive after talking about 2 statutes, and then uses the quote, by all other available and reasonable means. That certainly includes the use of the TOP program. In addition, Subsection N, although it obviously does not apply because Stacy was not incarcerated at the time, a difference between subsection N and subsection N as in Nancy and subsection N is the fact that that is an affirmative obligation on the defendant, and that's going to be an important distinction in both these areas. N provides an affirmative obligation. M allows us to use various methods for the United States to enforce. And I'm going to turn to my second point because that's a similar distinction. What the payment plan does is requires, as an affirmative obligation, an in personam remedy, which requires defendant to meet at least a minimum standard. And as this court has found in Faradidin, that is a floor, not a ceiling. That is just one avenue that we require the defendant to affirmatively start making victims whole. But in addition, the United States has many powers under its enforcement mechanisms. Separate and apart of defendant's affirmative obligation to meet his payment plan, we are then allowed, just like a credit card judgment holder would be, to enforce the judgment using all in rem remedies up to the amount of the judgment. And in this case, the district court made very clear that his criminal restitution was due immediately. The TOPS program is just one avenue where the United States is able to make the victims whole. In addition to that distinction, there is within the statute specifically, there is both in rem remedies and in personam remedies, and the United States can use both. And you'll find the in rem remedies, which is what the TOPS program, the TOP program would be under 3613, as well as 3613A would be the in personam remedy. And what I mean by that is, Your Honors, if Stacy doesn't comply with his payment plan, then the United States, and this is a sword specifically of criminal judgments only, where under 3613A, there can be serious consequences, such as being resentenced, being found in contempt of court. And that's because that's an in personam remedy. The administrative offset program is an in rem remedy, and we should have, as the United States, just as many rights as a credit card judgment holder. The last thing, Your Honors, I'll leave you with is just that, although in this case it is the victims of the crime, because this was a bank fraud criminal restitution judgment, are institutional victims. But any ruling that the court reaches in this arena would affect all restitution, whether it is an institutional or an individual victim, including sex trafficking victims and citizens that have lost money through fraud through no fault of their own. For that reason, if the court has no further questions, we would ask that the court either remand with instructions to dismiss for lack of subject matter jurisdiction, or if this court finds jurisdiction, to affirm on the merits.
Thank you, Ms. Rady. Mr. Nazarian, we'll go back to you now for rebuttal argument.
Thank you, Your Honors. Your Honors, to the United States' point regarding jurisdiction, I do believe that the title is particularly telling of that statute. For 1346, it is titled United States as a Defendant. We believe that 1346C confers jurisdiction on the district court to determine any set-offs where the United States is a defendant and they have a claim against a plaintiff. In this case, we believe that is exactly on point here, based on statutory construction. With relating to the administrative offset as a whole, though defense counsel has come up here and said, well, this implies that the United States should have equal grounds as a creditor. As Judge Hamilton had earlier specified, we were focusing on a very narrow carve-out to these statutes, specifically relating to a personal injury perpetrated by the United States government while incarcerated. The problem that we have, and the argument that we've made as it relates to the Eighth Amendment, is that by allowing a individual to have this restitution and this administrative offset, they can never truly be made whole from any injury, personal injuries, that they've sustained while incarcerated. That would be authorizing, and by its very
So you think you've got it you think this would be unconstitutional then?
Yes, Your Honor.
Okay, so do you think a damages remedy is required under the Constitution for all constitutional violations?
Not necessarily, Your Honor. But I believe in this particular case, where you have a personal injury for an injury that is sustained while incarcerated, something that is...
You don't even have a constitutional violation, right? You have negligence.
Yes, Your Honor. That is
Okay.
correct.
And even in the case of proven deliberate indifference towards serious health needs of an inmate, the defense of qualified immunity could be available, correct?
Correct, Your Honor. But there is carve-outs specifically for the FTCA.
The FTCA has very little to do with the Constitution. I understand the policy argument that you're making, but you think this is a bad idea.
Yes, Your Honor.
Stretching it to say it would be unconstitutional to deny relief here is way beyond anything that I would see as justified.
And obviously that is, to your point, Your Honor, we believe that it is an extreme circumstance. We believe that the slippery slope here is more telling. Though in this particular case, Andrew Stacy had a hip replacement. It is, of course, relating to medical negligence, but it gives way to a far greater worry and far greater fear of an individual who is deliberately attacked, injured while incarcerated, and have...
And the Supreme Court has been dismantling the damages remedies under the Eighth Amendment and Bivens over the last couple of decades without apparent constitutional qualms.
Yes, Your Honor, that is correct.
So how do we get to a conclusion that we need to agree with you to stay within the Constitution?
I think that specifically it relates to the mandate that is part of 31 U.S.C. 3728 that requires that the Department of Justice withhold any funds for these individuals. I believe that is the main issue. All of the other statutes that have been cited by the defense are permissive. It is an allowance by the United States. There are certain requirements.
So if the government had discretion to exercise this set-off, you think that would address this problem?
I think that it could potentially address this problem, though I believe that Congress would have to enter some sort of further requirement or limitation on the U.S. government for instances where you have an individual who is injured in incarceration or under the custody of the United States.
Thank you.
No problem. I see that my time has elapsed. Your Honor, may I conclude briefly?
You may.
Your Honor, for all of the reasons that we've indicated, we believe that Andrew Stacy's administrative set-off should be overturned and the district court's ruling comport with both constitutionality and the actual language of the statutes as we've cited in our argument and briefs.
Thank you, Mr. Nazarian. Thank you, Ms. Rady. The case will be taken under advisement. We'll move now to our last case of the morning. This is Appeal 22-1972, Martin versus Kijakazi. We're going to begin with oral argument from Mr. Farr.
Good morning, and may it please the court. My name is Eric Farr, counsel for appellant. In this case, the ALJ committed reversible error when she refused to adopt the opinions, the only medical opinions available in the record, opinions provided by her state agency's own consultants, and did not seek new medical expert opinion to interpret complex objective medical imaging, specifically x-rays and MRIs, that postdated Mr. Martin's date last insured. This case is very comparable to McHenry versus Berryhill. In both cases, the issue was whether potentially dispositive medical imaging that was only available after the date last insured might refer to the condition actually having existed to the same level of severity prior to the date last insured. In McHenry, it was a period of 4 months. Here, it's a period of 5 months. If he had been found limited to light work at any point prior to his date last insured, since he could not do his past work, he would have been found disabled by the judge and entitled to disability insurance benefits, which would have resulted in a higher benefit amount to him that wasn't dependent upon income and resources and given him access to Medicare. So it made a real impact to him in having this denied. I really am not familiar with any contrary case law, and the appellee's response in the response brief was largely based around the idea that this argument had been waived because it wasn't raised at the district court level. However, this same argument was basically raised in largely the same format in district court. I actually believe that we start with his filing date, which was in June 2018. His alleged onset date is June 2016. Maybe a medical expert would look at that and say, there's no way I'm going to say chronic degenerative changes evidenced on x-ray could go all the way back 2 years. But it seems a lot more plausible that a medical expert looking at that data might say, okay, it goes back 5 months, especially since her own
Mr. Farr,
state
that sounds to me like an invitation to speculate. Has any doctor opined that Mr. Martin had disabling impairments before December 31, 2017?
Yes, Your Honor. When the state agency consultants reviewed this, they were reviewing for a disability insurance benefit period, which would have been...
They examined him in late 2018 and wrote that they were providing a current assessment, correct?
For disability insurance benefits.
Current assessment.
Well, if the current assessment had referred to after the date last insured, then they would have said, as they do in other cases, that there was insufficient evidence. That's a finding they routinely make, that there was insufficient evidence for the period they're reviewing.
So you think they were opining that he was limited to light work before the date last insured?
Yes, Your Honor.
That's pretty hard to get off. I frankly have trouble getting that off their examination reports.
Even if you did not view those examination reports to say that it referred to the relevant disability insurance benefit period, then we still have a situation that's very comparable to McHenry, because we're still dealing with potentially dispositive evidence that comes just a few months after a relevant change in benefit eligibility.
Do we get ourselves into trouble by implying onset dates, though? Notwithstanding the use of the word current with regard to the agency physicians, there's evidence in the record here that he got better between 16 and 18. He's lifting weights, walking around. Is your request for us to imply the onset date, obviously it's for this case, are you also asking us to make it a ruling for other cases?
Sorry, Your Honor. No, I wouldn't actually request that we imply an onset date here at all. Rather, I think the issue is that the ALJ, even though she had the ability to consider an earlier period, interpreted her agency's rulings to say that she could not look at an earlier period in time. And really the only request I'd ask today is that this court remand so that she could actually have a medical expert interpret that objective imaging. I'd rather us not get into speculating as to when it might apply.
So, I mean, but we've got this new Social Security ruling in 2018 that makes, I think, awfully clear that that's left to the discretion of the ALJ.
The phrasing of the ALJ's opinion, at least as I read it, is that she believes she was not allowed to make a decision prior to when medical evidence was established. And I think that's reflected in the onset date that she picked, because there was nothing special about the primary care visit she picked as the onset date. That was in February of 2018.
February 5th.
Thank you. And that date, he just goes into his primary care doctor for the first time, says, I have a history of back pain, doesn't have any specific complaints that day. Comes back the next time, I think at that point he's in a wheelchair for a period of time.
In May.
And they get x-rays and they say, okay, there's some degenerative changes here. I think the fact that between a few months, he's going from this isn't a primary concern to this is a big issue, where there hasn't been any big injury in between, is reflective of his allegation that there's a fluctuating level of intensity between 2016 and 2018. Now, again, maybe a medical expert would say, there's no way we can infer that that pattern would exist all the way back 2 years. But I think a medical expert very well might say 5 months earlier, yeah, that seems reasonable.
The discretion that Judge Hamilton referred to, in the policy statement, that's discretion to hire a medical expert. So how do you get around that? It's pretty clear it was within the ALJ's discretion. She didn't have to get a medical expert to help her with this onset question.
There would be no other way for her as a layperson to interpret those MRIs to refer to an earlier onset date than it would be for me to speculate as to when it might apply as another layperson. This isn't like referring to evaluating a subjective symptom complaint or referring to here's the establishment of a treatment pattern over time. This is just, if we look at this imaging report, what does that mean? And as a non-expert, I can't really tell you what that means or how long that degenerative change might have existed. But it also seems very unlikely that the ALJ's interpretation is reasonable here to say that he shows up to a primary care doctor for no particular reason, and boom, now he has this severe degenerative change that limits him to light work.
That sounds like you're trying to find error in a judgment the ALJ made in your client's favor, right? Instead of going with an onset date of May of 2018, she's giving him the benefit of the doubt back to February, where at least there's some medical evidence. He saw somebody. But one of the difficulties I have with the argument here is that you seem to be trying to reverse the burden of proof. The burden is on the claimant to come forward with medical evidence of disabling impairments, and you're trying to say we didn't have to do that. It was an abuse of discretion by the ALJ not to go look for such evidence for us.
Well, in Kipling versus Saul, which is an unpublished decision, this court did say that it's the claimant's responsibility to bring forth evidence. It's not the claimant's responsibility to provide it.
Right?
I'm sorry,
The
Your Honor?
statute makes that burden pretty clear, doesn't it?
To provide evidence, Your Honor, yes. Which he did provide evidence of a degenerative condition. And SSR 18-1P would direct that if you have a non-traumatic impairment, you can look to subjective symptom reports to look to an earlier period. I would say that I take your point that I am also kind of arguing, hey, she gave him a benefit for that maybe. I think either way, she doesn't really have a clear explanation for why she picked that date. I mean, if she wanted to deny him until a later date because she had medical experts telling her, hey, the imaging doesn't support an earlier date, I think that would be a reasonable outcome. If she said, okay, now that I've had a medical expert look at this, or based on what my state agency consultants have said, then we could pick an earlier date. That would be fine. Here, she's just picked a completely random date out of a hat.
Well, she had to pick a date.
Random. Come on, counsel.
She picked a date that was in the document, and she was pretty generous, wasn't she?
I don't think it is too generous to again, this man is I believe he's currently married still, and his income situation would suggest that he's not actually going to get anything because of his spouse's situation. So it actually resulted in basically a nothing for him. Maybe it's generous on the record to say partially favorable, but the outcome's basically the same as denying him. Then I don't know that is a generous thing or giving him the benefit of the doubt.
Want to reserve the remainder of your time?
Yes, Your Honor. Thank you.
Thank you. Ms. Hahn, we'll now move to you for argument from the Commissioner.
May it please the Court, Counsel Lou Hahn on behalf of the Commissioner of Social Security. I'll begin by recounting some of the testimony that Mr. Farr did not get into in his presentation, but that we summarized in our brief. This was at the February 2020 administrative hearing where Mr. Martin appeared with his attorney before ALJ Livia Morales. During that hearing, in response to questioning by both the ALJ and his own attorney, Mr. Martin confirmed that after injuring his back in June 2016 at a job where he was lifting a heavy bag of, I believe, water softening salt that was 40 pounds, he hurt his back but quickly improved. He even said by his own words he got to the point where he didn't think much about it. He, as Your Honors pointed out, was walking 2 miles a day, lifting weights, going about his activities between 2016 and 2018. And as Your Honors realize, and as Mr. Farr and the government agree on, the operative date for his insurance-based benefits, the disability insurance benefits piece of this case, which is the only one at issue, that operative date was December 31st, 2017. So by Mr. Martin's own testimony, his own statements, he had no back problems. In fact, he was...
I wonder if that's truly fair. His testimony was that his back problems came and went. And when they went, he could lift weights and so forth, so on. And his testimony was also that he didn't need the rolling walker until 2018. But he certainly had problems lifting in that period between 2016 and 2018 when his back problems were present.
Your Honor makes a very good point in that he did his job, the prior job that he had, at a heavy level. He was lifting heavy at that job. He his testimony talked about the amount of weight that he was required to lift at the job that he no longer could do. And when asked point blank, however, by his attorney, did you have back problems prior to 2018? He answered, as we state in our brief, unequivocally, no.
That was in the context of the walker. I'd like to, back problems that necessitated the use of the walker that you are now using. You see, so that's, I think, somewhat unfair reading of that particular part of the testimony. But Mr. Farr does make a good point that this February 2018 date, that's just an internist visit. It's not a visit to diagnose a back problem, to consult about a back problem, to complain about a back problem. He's listing back pain as one of many symptoms when you give your history to a doctor. The ALJ, I read the decision, and she does seem to clearly say that she can't rely on anything other than objective medical evidence to find an onset date. That would seem to contradict SSR 18, or the policy statement. I may be giving maybe missing a letter or a dash or something there. That would seem to contradict the policy statement, which clearly, this October 2018 policy statement, which says that the administration can look to symptoms or medical evidence or symptoms to establish an onset date. And an onset date can happen before there's an actual medical record. Her decision clearly says, I can't find an onset date before an established medical record. So can you just address that?
Absolutely, Your Honor. Social Security ruling 18-1P, which we cite throughout our brief. That's the ruling that Your Honor is inquiring about. And in that ruling, it talks about the establishment of an onset date of disability. But to get to that ruling, and when you read the language of the ruling, an individual claimant must establish that he or she is entitled to disability. And in going back to the 5-step sequential evaluation process, one of the steps, number one, is, was an individual engaging in substantial gainful activity? In this case, no. But number two, is there evidence of a medically determinable impairment?
Don't we have that finding here, because she finds that based on the May 18 x-ray? So she's found the impairment. Now it's merely a question of an onset date, which is a separate inquiry.
To divide between the two kinds of benefits here, there's the Title 16 benefits under the Social Security Act, which are resource-based, and that's the supplemental security income benefits. That was part of the claim here. There's also the insurance-based benefits under Title II of the Act. And in that one, that is very much dependent on a period of insured status. So when the ALJ in Step 2, and this is found on page 4 of 9 of her decision, on that page of the decision at the second step is where the ALJ discusses the existence of a medically determinable impairment. In that one, the operative regulation is 20 CFR 404.1521. And in that regulation, that's the regulation that describes how to find a medically determinable impairment. That's a threshold question in which an individual must furnish evidence to show the existence of a determinable impairment before moving on. At that step in this particular claim, ALJ Morales dismissed the insurance-based benefits only. She proceeded through the remainder of the evaluation process based on the other type of resource-based benefits, which she found that Mr. Martin was entitled to. But at Step 2, she found that in searching the record that Mr. Martin and his attorney furnished, that they confirmed at the hearing was complete, she was unable to find evidence of any kind of medically determinable impairment without going to the ruling, Social Security ruling 18-1P, because that ruling, again, is premised on the establishment of an individual has already established entitlement to benefits, as in they've already furnished medical evidence showing an impairment. But here, what the ALJ is doing, and this is fairly nuanced, but in that step, she is saying, I cannot find any medical evidence of an impairment prior to the visit to the internist on February 5th, 2018 to Michael Cauty, and it was Dr. Cauty's treatment notes that the ALJ referred to as the first any kind of medical evidence in this record. So for that threshold step 2 issue of was there the existence of a medically determinable impairment at some time before the lapsing of the insurance benefit period, she found no. She dismissed that portion of his benefits claim at that step, and she moved to the next 3, 4, and 5th steps of the sequential evaluation process for the resource-based benefits under Title 16. So it's an interplay between both the regulation 404-1521 as well as 18-1P, which in this case the ALJ did not run afoul of any regulation or ruling. The ALJ was tasked with being the fact finder, and that's exactly what she did. She evaluated the facts, she referred to Mr. Martin's own testimony, she referred to and did discuss on page 7 of 9 the prior administrative state medical findings from Drs. Whitley, Drs. Corcoran, that were made in September 2018 and January 2019, respectively. What the ALJ did here with the record, with the evidence that was provided by Mr. Martin and his attorney, was reasonable. There's simply, in looking at this, no legal or factual basis for this court to send this back. And as Mr. Farr, if I'm understanding his oral presentation today, is saying that it would have been reasonable for the ALJ to find a later period of time of disability starting in May, or it would have been reasonable to find some earlier time prior to the end of the year in 2017. But specifically what the ALJ did here, which is using a medical record which said positive for back pain on February 5th, 2018, is based on his argument, unreasonable. That either it could be more prejudicial to give, I suppose, his client fewer benefits for the difference of February to May, or earlier. But what this court is looking at, and it's looking at the final agency decision here, which is the ALJ's March 2020 decision, is was it wholly unreasonable? What the ALJ did to resolve the issues in this case was no reasonable mind able to make this determination. And it's our position that the ALJ was reasonable in this determination on this narrow issue of the insurance-based benefits.
Thank you, Ms. Hahn.
Thank you.
We'll now move back to Mr. Farr. We'll give him a 1 minute for rebuttal.
Thank you. I'd just like to make 2 points quickly. First, SSR 181P directs that you can rely upon subjective symptom complaints and reports from claimant or family members or friends or whatever else when considering whether a medical impairment exists earlier than the medical evidence available. DIB, disability insurance benefits, and supplemental security income both use the same sequential evaluation process. At step 2, it's not a separate process for DIB versus SSI. It's the same evaluation. She established that a medically determinable severe impairment existed in the form of chronic degenerative disc disease. Then the issue becomes, can we establish that that impairment existed earlier than the medical records existed? So we already have the severe medical impairment. She thought she couldn't even look to an earlier period. So that was just disconcordant with agency policy. Secondly, the judge did not have to find that this man couldn't do any work at all. He just couldn't do his past work anymore. It seems like we don't have a lot of doctors' opinions here, but the doctors who looked at it at least said he can't do more than light work. I don't think that that's highly unlikely to have changed in the few months earlier, and I see that my time is out, so thank you.
Thank you, Mr. Farr. Thank you, Ms. Hahn. The case will be taken under advisement. That will close our oral arguments for today. We'll close the record until tomorrow.